So we should point out that court is over. The sentence has been imposed, an unconditional discharge. And as we bring in Mark Levin for his commentary on this, Mark, Judge Merchan imposed no jail time, no fine, no punishment that anyone can discern, with the exception that he is now branded Donald Trump with a scarlet letter of a big F on his forehead, that he is a convicted felon. How does all of this strike you?
I'll tell you how it strikes me. When you look at cases throughout history, not just in the United States, but really all over the world, this will be remembered as one of the worst. This will be remembered as an absolute injustice from the beginning. Now, I haven't been able to listen much because I was at the doctor to some of the commentary, but I would say this about interlocutory appeals and the New York system, and they don't normally take them and so forth. It's all quite true. The problem here, and I think the four other justices on the court, the originalists, understood that it was very, very crucial that the Supreme Court take up this case the way they took up Bush versus Gore, because it's the most extraordinarily outrageous case in modern times. You've got three great lawyers here who are telling you over and over again why that's the case. You're stuck in a legal system that is, for whatever the reason, highly corrupt, highly partisan. But the Supreme Court had a responsibility to defend the Supreme Court, to defend the federal judiciary, to defend the federal Constitution. You have an elected left-wing, bomb-throwing prosecutor. You have a completely rogue state judge at every step. He orchestrated this thing just as he orchestrated today's abomination. You have four justices who clearly wanted to take up this case. They had enough reason to do it. The arguments were laid out not just by President Trump's lawyers, but also by former Attorney General Meese's lawyers. He filed an amicus, a friend of the court brief here. This court, if it had Rehnquist as the Chief Justice, if it had Scalia on this court, this would have been a 6-3. They would have taken this case and fixed it. Now, what do I mean by fix it? Depending on what the state appellate courts do, this case is going back to the Supreme Court. Now, what's the Supreme Court going to say? We're not going to take it? Of course they're going to take it. Well, what are they going to say then? They just effectively gave their imprimatur to the process. To the process. They said, let the process play out. That's all we know from this order of 3 sentences or whatever it is. Let the process play out. No. You don't let a corrupt process that these gentlemen have been talking about from beginning to end play out, particularly when you're talking about an incoming president of the United States, where the appellate process for this corrupt process will be going on while he's president of the United States. So this court had an extraordinary responsibility, like it rarely does, to set this straight. And now the precedent is set. That is, that you will be able to drag candidates, maybe for president, some DA, through a corrupt process that has to play out all the way to the end until the Supreme Court's going to look at it. I strongly disagree with what Roberts and Barrett did here, throwing with the three typical hardliners on the left. I strongly agree with, I think, is the impression of the four other justices. It was close. It was 5-4. Who probably said, no, we've got to fix this situation now. We cannot give our court imprimatur to this process. So they did not defend the federal judiciary. They did not defend the federal constitutional system. They did not defend themselves. And even when they eventually take up this case, it's far more complicated now for them to explain why they're taking up the case and why, God willing, if the state appellate courts don't, they're going to reverse. I think it's an absolute abomination.
Dana, you want to weigh in here?
Mark, could I ask you, does this mean that the gag order is now lifted? I'm assuming so because he was allowed to talk. And I'm sure he's got a lot of pent-up thoughts about all of this, but maybe wants to move forward because he's got a lot on his plate as he tries to hit the ground running in 10 days.
I don't know what they've done. If I'm the president of the United States, I ignore the gag order. I tell the judge, you go ahead and hold me in contempt if that's what you want to do, and then I will litigate that issue to the end of the earth. He's the president of the United States. He needs to be able to speak freely. That gag order was just part of a long list of unconstitutional acts by this man, and he should violate it. And if the judge doesn't like it, too damn bad. What's he going to do? Send him to prison? Then the Supreme Court will take up the case. Then he can resolve the matter. You see, what Merchan did here, the reason he didn't imprison him or give him an ankle bracelet or really penalize him in any way was because he knew the Supreme Court then would take up the case, because he would be interfering with the function of the federal government. He would be interfering with the office of the presidency. So what does he do? This guy's a schemer. He says, you know what? I'll put I'll put the scarlet letter on, but I'm not going to punish him, quote unquote, because then I will have a problem with the Supreme Court. And just briefly, think about that. So in other words, if he said I'm going to imprison the president, or he says he's going to get an ankle bracelet, or I'm going to fine him for $500,000, or I'm going to do all these other things, does anybody really doubt that the Supreme Court wouldn't take that up? The Supreme Court would take it up, and it would take it up in part because of a half-century-old 2000 memo by the Department of Justice Office of Legal Counsel. So Merchan says, I'm going to skate this. And with the abomination to me on top of everything else with that short order was they actually cite the fact that really Merchan's not going to punish him as one of the reasons to let it go. They were played. Those 4 justices in the minority, they knew that. They saw that. I'm sure they did. And again, I think a Rehnquist would have seen it. A Scalia would have seen it. They had more reason to take this case than they did Bush versus Gore, and now we're stuck with it.
Mark Levin, thank you so much for joining us. We just showed you some video of Todd Blanche, President Trump's lawyer, who has left the courtroom.
I'm Steve Doocy.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.